you, Chill. Good afternoon and happy Law Day. And thank you for your patience. I'm Leslie Stein, the director of the Government Law Center at Albany Law School and the home of the Fair Trial Free Press Conference. We are very pleased to support the conference, the principal purposes of which are to promote and provide education about the essential rights to a fair trial and a free press, and to facilitate discussions between judges, lawyers, and journalists regarding the interplay of the related legal, constitutional, and ethical considerations. We regret that we were unable to present this program in person as originally planned due to unforeseen circumstances. However, thanks to available technology, we're pleased to be able to offer a superb panel of experts remotely to discuss important issues of our time, most appropriately on Law Day. Law Day is observed in the United States annually on May 1st to celebrate our legal system and the freedoms we enjoy. This year's theme is Voices of Democracy, a fitting theme for today's program. Our distinguished panel of judges, journalists, and lawyers and law enforcement officials will explore the legal, political, and ethical issues that arise during a highly publicized and turbulent criminal trial involving a gubernatorial candidate indicted for federal financial fraud. Panelists will discuss the interplay of the Sixth Amendment right to a fair trial and First Amendment rights to attend and report on trials, including access to courts for community media and corporate media, gag orders, anonymous juries, police conduct, and protection of the press and its sources. You should have received the hypothetical in your online program materials. The discussion today will be moderated by the Honorable Albert Rosenblatt, retired judge of the New York Court of Appeals, and Rex Smith, former editor of the Albany Times-Union. Our distinguished panel of judges, attorneys, and journalists includes the Honorable Darcel Clark, Bronx County District Attorney and former Associate Justice of the New York State Supreme Court Appellate Division First Department, Honorable John Croden, District Court Judge of the United States District Court for the Southern District of New York, Michael Gerber, a Deputy Commissioner of Legal Matters for the New York City Police Department, Nicholas Gravante, partner at Cadwalader, Wickersham and Taft, Dana Green, Senior Counsel at the New York Times Company, Joseph Kretsch, partner and media and First Amendment practice leader at Boies Schiller Flexner, Tandy Lau, public safety reporter for the New York Amsterdam News, Nicholas Lemon, Joseph Pulitzer and Edith Pulitzer Moore, professor of journalism and director of the Columbia Global Reports and Dean Emeritus at Columbia Graduate School of Journalism. And last, but by no means least, Martina Stewart, team leader on legal intelligence for Bloomberg Law. There's much to discuss in limited time, so I will leave you to read more about each of them in your course materials, and I encourage you to do that. In addition, to learn more about the Government Law Center, I refer you to our website, albanylaw.edu/GLC. Before we begin the program, I would be remiss if I did not recognize and thank a few people who were instrumental in making this program happen. Government Law Center staff members Richard Rifkin, Chell Miller, Lisa Rivage, Tamar Reiner, and the Albany Law School Communications Department, as well as the Fair Trial Free Press Board officers and members, Honorable Albert Rosenblatt, Rex Smith, Mike Greigel, Diane Kennedy, Steve Clark, Patrick Woods, and John Gross. Finally, a couple of housekeeping items. We hope to have time for questions and answers from the persons attending the program following the panel discussion. If you have questions, please submit them in the Q&A box, which we will be monitoring. The chat box will not be available to you. And as you can see on your screen, in order to get your CLE credit, don't forget to submit your affidavit. And now I'm going to stop talking and pass it on to Rex and Judge Rosenblatt.
Well, thanks very much, Judge Stein. It's really great to have this opportunity. Judge Rosenblatt and I have been involved with Fair Trial Free Press for more than 2 decades. I don't know if there's ever been a panel more distinguished than that which we have today. In fact, it's kind of an embarrassment of riches to have these experts and to know that we will be able to get to only a fraction of the expertise. But those of you who are taking advantage of this, who are participants, especially those of you who are getting continuing legal education credit, will have the benefit of some truly terrific experts in their field. We always proceed with the enjoyment of the hypothetical, knowing that the consequences of our comments here are really not significant because it's only among ourselves, but that this gives us an opportunity to fully explore some of the issues that really confront the intersection of the legal system and our First Amendment rights as practiced by journalists. And so we will proceed with this, and Judge Rosenblatt and I will sort of alternate as moderators along different parts of it. We're assuming that most of you, hopefully all of you, have had a chance to read the hypothetical so that you sort of know where we're going today. It is included near the top of the material that you were forwarded. So please consult that. If any of this seems out of your out of anything that you were expecting. Any other bit that Al, that we should check in with before we plunge forward?
Go, let's roll them.
All right, we're talking about a candidate once in future, perhaps, Jamie Tusk, a wealthy businesswoman who ran for governor, almost made it and did not get elected, but excited such an amount of enthusiasm among her supporters that they have now massed outside the courthouse where she's facing legal consequences for alleged financial fraud. This is, she is upset about the indictment, has done some work on social media to raise questions, let's say, proclaiming her innocence and denouncing the fake charges against her, and alleging that the the prosecutor who is coming after her is moronic and has even had some images seeming to attack him. I should note that the hypothetical has been intentionally structured with a lack of clarity as to whether we're in federal or state court, because there are some areas where this could be interpreted differently, and we may be able to explore some of that as we're going forward to this. But we should take a look at the fact first that we have Ms. Tusk tweeting that the judge in this case was unfair and a political hack who's out to get her. And the prosecutor therefore moves for a gag order for the duration of the trial for anything about the case which could interfere with a fair trial. And there is some delineation then, including as to what that should be. And I think one of the first questions might be to our district attorney, DA Clark, and a former judge, bringing her perspective to this as well. So you would be the one presumably who would gain some protection as a result of this gag order. Doesn't Ms. Tusk have her own First Amendment right to defend herself in the court of public opinion? Isn't this gag order therefore interfering with that?
Well, thank you for the question. First of all, as a prosecutor, it's not about fairness to the prosecution. It's fairness to the administration of justice. That's meaning both sides, everyone involved. So as a prosecutor, if we are asking for a gag order, it's because we wanted to make sure that the trial is fair for both sides. That's a balancing act between, you know, your individual rights to, you know, your freedom of expression, as well as the freedom of having a fair trial. So that would be made only if we felt that statements made by any of the parties, including the DA's office, anybody can make this application, because it could also be done. The defendant could make one against the people because they don't want us to say certain things or put things out. We want to make sure that the administration of justice is fair. So this will be so that we won't taint a possible jury pool, so that the witnesses may not be threatened in any way, that there's no disparaging remarks about any of the parties of the case. We want to have the trial in the courtroom where the evidence unfolds and everything is fair there, not on the outside. So to move for a protective order has to be very specific because, of course, the courts do frown upon on gag orders. They're presumptively unconstitutional because of the right of freedom of expression. So you don't want to hinder that. But at the same time, when you're talking about a criminal trial, there are a lot of other constitutional rights and freedoms that go along with that you want to make sure that it's balanced. In the end, it's about fair administration of justice.
All right. Well, that makes a convincing argument, but Dana Green, senior counsel for the New York Times, if you're the counsel for the Daily Bugle in Metropolis's largest newspaper and your reporter Sandy Scoop is concerned, I would presume you'd be concerned about this kind of an order on behalf of your client.
Yeah, we do have these things come up from time to time. I mean, I think the point that there's a balance to be struck here is exactly right, and you know, it's not uncommon for there to be gag orders that are very limited in scope, you know, and ensuring there aren't threats made and things of that nature. And in my experience, it's relatively rare for the media to be in a position where the gag order is so broad that it's sort of impeding the ability to report on the case to the level where you would see this kind of emotion. Yeah, and looking at this one, it doesn't appear on the face of it to me that the subject matter of the gag order is inappropriate or improper in terms of limiting threats. What sort of stands out to me here would be that it's targeting or disfavoring one recipient over another, saying that she may not speak to public media, but of course could make all sorts of other public statements, and that raises, you know, significant constitutional issues in terms of disfavoring the media's ability to receive information over other groups, and of course goes to whether or not the gag order is even effective, which would be another constitutional issue because it you know, wouldn't prevent, for example, making a political speech, but it would prevent speaking to public media.
And one question might be just a quick one for Judge Cronin. Would the media even have standing to intervene in this? If let's say Ms. Green, on behalf of the, or actually she's being Jan Watchover, the newspaper counsel, if she were to intervene, do you think she would have standing to argue on against the gag order?
Sure, Rex. Thank you. Let me just caveat this by saying what I think is obvious, since I'm currently a sitting federal judge. I can't opine on how I would actually rule under any of these scenarios, especially since something like this could potentially come before me. With that said, I think there would be an argument based on how this gag order is described, that the media would have standing as an injured party and would be able to intervene. I think that's typically how this would potentially play out.
But probably, so the person who this most affects would be Mr. Gravanti's client. Well, assuming that we're making you, for the purposes of this, Joe Pagnacio. By the way, that name was this scenario actually we used last spring in Albany when we actually used the previous version of the or last fall. So Mr. Gravanti, what are you going to say on behalf of your client facing this kind of a restriction?
I think I would argue that the restriction in and of itself, a restriction in and of itself that protects the integrity of a trial, the safety of witnesses, the safety of a judge, undoubtedly is constitutional and appropriate in a certain case, especially in a case like this where emotions are running so high. On the other hand, you have to look at the breadth. You have to look at what the statements are that are actually prohibited, and make sure that a judge who is called moronic in the press a judge who's called a political hack, a judge who is accused of being out to get my client. My client makes those kinds of public statements at his or her own peril in any case, because in the end, the judge has a lot of power over what happens at the end of the case should the client be convicted. So I do think that there is obviously there's a strong motivation for a defendant not to go over the top and make ridiculous comments that are simply going to anger the judge and cause public support to get out of hand. I think there is a right to marshal people and marshal public opinion towards something that you believe is unfair, so long as you don't cross the line and either intimidate witnesses who are going to testify from wanting to testify, because I think that it's sort of it's scary enough for a witness to know they have to come in and be cross-examined at a trial. They don't want people showing up at their house. They don't want people harassing them at their places of business or their family members. And it's the same thing with judges. So I think the breadth of the order, as well as the way it's applied in a particular case, is what is most important. And I think that regardless of how you craft an order, whether it's actually violated or not, and how the facts are applied to the order is the most important aspect of this. So I would argue that although the order on its face might not be overbroad because it has a laudable motivation, whether a client should actually be held in contempt for violating it is very fact specific, depending on the particular statement made, and for that reason, it's got to be carefully monitored.
Let me just, before we move on to the next section, just talk to the journalists here. Martina Stewart, Bloomberg Law, who happens to be a lawyer in addition to being a journalist, which is a good standing here. Would the existence of a gag order in any way inhibit your reporting?
I don't think so. I mean, I think what I would probably do is talk to my reporter and and that would probably be Tandy in this case. And then maybe Dean Lehman, who was the dean when I was at Columbia J School, would probably be like my senior management. And I would probably talk to both of them and figure out what we wanted to do. And then maybe call up my general counsel and ask for some advice. But I don't think you can be sort of cowed by something like this. And I would at least want the advice of counsel to try to figure out what we can do or where we might want to try to push back a little bit, even a little bit against what the judge has ordered. And I should mention in the DC Circuit case from late last year, where a gag order was upheld, the one thing that the court allowed was for a former president, I won't mention his name, to comment about the special counsel. And so that was, to me, very interesting that comments about Jack Smith were allowed. And in a lot of other ways, that gag order was upheld by the DC Circuit.
Mm-hmm. And so, Tandy, as a reporter handling this sort of a story, you're not going to be at all cowed by a court order telling you that seems to stop someone from talking to you. It's not going to stop you from talking to them?
I would say probably not. I think in a situation like this, obviously we would really rely on on our counsel, right? To really inform us on the proper decision in terms of whether or not we should be talking to this person. But in a story like this, I think the important part would be on our end, to make sure that the public is informed, right? So if the best way to inform the public is somebody talking to us, which it usually is, then we would probably have to pursue that avenue. Obviously, we are journalists, not lawyers, so although we do have journalists and lawyers here who do both at once. For most of us, we are just journalists. So basically, what our counsel tells us in terms of like what we should be doing, I think would be what we would feel comfortable doing. Now, of course, as a reporter, we have a nose for this stuff. So if something smells bad, it could be something that we want to take up with our editor counsel. But I think in regards of a story like this, I think really we do the work, and we let other people we punt the ball to people above us to really take care of the extraneous issues in situations like this.
So maybe, Nick Lemon, we just ask you to take a step back. The seeming intersection of interest between the first and the sixth on this case that we're laying out, are we seeing an increasing incidence of this? And is there a way that the rise of hostility to the media is that is being incited in the public is going to increasingly create headaches for the courts in trying to determine how the parties in this kind of an instance intersect? I think you're muted there, Nick. We're gonna.
Was that addressed to me?
No, okay.
Okay.
So
Other Nick.
I guess I would say that, for people my age and your age, Rex, we think back to the golden age of media law being things like New York Times v. Sullivan and the Pentagon Papers case and so on. But, I don't think there's a lot of us who think the golden age is coming back. And there's a couple of reasons for that. One is, at least at the Supreme Court level, that this court is not super media friendly, and a couple of judges have sort of indicated without much prompting that they'd be open for reopening the New York Times v. Sullivan standard and maybe other aspects, press-friendly aspects of media law. And the other is, it's hard to explain in the full dimension of this to non-journalists, but I just want to say, I know it sounds like stating the obvious, we are not a licensed profession and we do not have a code of ethics. So, we can do whatever the heck we want until somebody stops us. And we have an impulse, like I have a dog I love very much. And if I say to him, I just came home from the butcher shop with a fresh steak, and then I have this bag of healthy dog food that your vet thinks you should eat, you decide. I don't need to tell you what he's going to decide. And so it's really on me to tell him to eat the healthy dog food and put the steak in the freezer. Similarly, like with this gag order, if you're Sandy Scoop, you're going to say, I don't know how I found the material in my sensational story. I didn't say in the story that I was violating a gag order, and you read it and it was a great story and it got me on the front page. So for whatever reason, journalists have a natural impulse to get the story and to think of whatever allows them to get the story as sort of right and perhaps superior to what the law says, unless somebody really reins us in. We live in a pluralistic society and people push in different directions. I think the death of the long ago now heyday of the established mainstream media is in effect, and we see this in the case, is going to erode whatever privileged position the press has left, because anybody can say they're a journalist, anybody can say or do anything, and it's harder for us to go out into the public square in front of non-journalists and say, you can trust us because we're the media establishment, So I think all those kind of change the atmospherics around what we can and can't do, but we're not going to self-limit, I guarantee that. So it's really a question of what you guys tell us we absolutely can't do. And then we might try to do it anyway, unless our general counsels really rein us in.
Before we move on to Judge Rosenblatt, Judge Cronin has a hand up and obviously a comment to make here.
Sorry about that. I just thought, Rex, before we moved on, if you don't mind, for the benefit of the participants, I don't know everyone's background here, I thought it might be helpful to take a step back and state something that I probably are pretty obvious, but why this is such a tough determination for a court to make when presented. You could have a gag order like the one presented in this hypothetical that is focused on the litigants. A gag order also could be more specifically focused on some of the people on this screen, precluding specifically the press from publishing certain information. I think that was the factual scenario in one of the first, seminal Supreme Court cases to deal with this, a 1976 case, Nebraska Press Association versus Stewart, where the gag order basically prevented the media from reporting on particular information. There was the confession of an accused murderer, I think. So like I said before, I've never had this, I think I said this before, I've never had this issue before me. I instruct jurors that they should not be talking about a case while the trial is pending. But beyond that, I've never been presented with a gag order. But one of the reasons why this issue is so difficult is the number of just fundamental constitutional issues that are implicated and that kind of pull in different directions. You have the First Amendment concerns for litigants and the press. You have the freedom of the press to be able to report on what's going on in the case. You have the First Amendment freedom of speech and expression. And those are particularly heightened here because a gag order could potentially act as a prior restraint on speech. When there's a prior restraint on speech, the Supreme Court has entailed a very heightened scenario. It's very hard to overcome. Justice Berger, in the case I mentioned before, Nebraska Press Association, called it the most serious and least tolerable infringement on First Amendment rights. So when you have a prior restraint on speech, there's a huge burden that the infringing party would have to meet. Sometimes that's national security concerns, but something very high. And that's why, as other people have said, an overly broad gag order here that operates as a prior restraint on speech can be very problematic. Now, there's another First Amendment concern here as well, and that's the right of public access to the courtroom. The Supreme Court recognized that back in the early 1980s in Richmond newspapers versus Virginia. There's a First Amendment right for the public to know what's going on in a courtroom. And once again, absent very narrow exceptions, witness safety, a cooperating witness, something like that, everything that goes on in my courtroom is open to the public. And part of that means the litigants have a right to say what they wish to say. But when there's a situation that a gag order is being considered and there's a legitimate basis to consider it, that means there are countervailing concerns going on as well. And those are what was touched upon a bit today, including by the DA, and that's the right to a fair trial. In a criminal context, that's grounded in the Sixth Amendment, but chances are that's what's motivating the need for the gag order. It could be influencing potential witnesses, the concern that witnesses will be intimidated from saying what they truthfully, providing their truthful and honest testimony. It could be intimidating potential jurors such that they don't feel able to render a verdict that is fair and impartial. And we don't want any of that to happen in a courtroom. And there's another important point that I think DA Clark made as well, that this doesn't just apply to the defendant speaking or the defense attorney speaking. Prosecutors also must be very careful about what they are saying, what statements are being made to the press, what is said at press conferences regarding a pending case. A defendant is presumed innocent unless and until proven guilty. And if a prosecutor is making statements out there that are suggesting to the potential jury pool that the defendant committed the crime without having established that in a court of law, that can be problematic as well. So anyway, I just thought before we move on, I would give that kind of context here for why this, I think, for a judge would be so difficult. I mentioned that 1976 case, that again dealt with a different scenario here because there was a particular restraint on the press. But what the Supreme Court looked at in that case were three factors in deciding whether to impose a gag order, whether the publicity would harm the defendant's right to a fair trial, whether the gag order is the least restrictive means of possible to ensure the fairness of that trial, and whether it would be effective. And I think any type of gag order that is being considered would look at some variation of those factors, really focused on, is this the least restrictive means of achieving this effect, and will it actually be effective in any way? So I thought, Rex, if you didn't mind, I would just chime in with that before we move on.
A good grounding, thank you. And we'll get, I think we will hopefully have a chance also to get to that point of that you made about the narrow restrictions on the public access to the trial. Some may say that given contemporary communication standards, including video coverage, that the courtrooms are not, in fact, accessible to the public as they might be under contemporary standards. Judge Rosenblatt, you want to pick up from here and see where we go?
Yeah, as we know from the script, the next phase of it involves a contempt proceeding. So I'll want to straddle the phase that we've just done with the next phase, and must say that I was really impressed with the presentations, the reaction, both by Dana Green of the New York Times and Nick Gravanti, both of whom seem to say that the gag order here, or the gag orders in general, are okay in the public interest. I was a little surprised to hear both people say that, but I'm reassured to know that there can be something closer to neutrality and less advocacy on the part of the participants, but there's plenty of room for neutrality. So I want to ask again here whether there's a distinction between the media and the defendant. The way this gag order is phrased, the New York Times is not a party. So as I look at this, the New York Times, I'm going to say, because I can say anything as a retired judge, 99 out of 100 judges, or 100 out of 100 judges, would give standing to the media to come in. I mean, it is so important. No one's going to say, well, you're not a party, so you're out. The First Amendment rights of the public are critical here. So, of course, most judges would let the media come in. But I would note that the media seems to be acting here entirely free of risk, because there's no injunction against them here. This gag order is not directed against them in any way, shape, or form. It says the parties, the attorneys, and the agents are prohibited, but it doesn't prohibit the newspapers at all. So I just wanted to point that out. But having prepared this gag order, and we put in some time, particularly Mike Greigel, in doing it, I would then ask both parties, if I were the judge, you both seem to say that the gag order is okay. Is it okay as written, or what is it, if anything, in this gag order that you would disagree with? So now we're out of the hypothetical, and now we're into the actual language of this gag order. And I would ask the media, you seem to be saying that you're okay with this gag order, and I would press to say, is that true? Then I would press the defense attorney, Nick Gravanti, and say, you seem to think gag orders can be okay. Do you have any objection at all to this one? And if so, what is it? So let's go back, because before we get into contempt, we have to answer this threshold question. So let me maybe start with Nick. You seem to say the gag orders are okay. Does that mean that you're okay with the one that is here worded in front of all of us?
No, I would not be okay with the one as it's worded. I think, first of all, defining agent, that's something that can be determined at a factual hearing, but this is incredibly broad when you go beyond a criminal defendant and his attorneys. Who an agent of a defendant might be. Does that mean any one of your thousands of employees who may work for you? It becomes very, very vague in that respect, and I think that's one problem. I
agree with you. I agree with you, Counselor. I'm going to strike the word agents. So it's the party and the lawyers. Consider it stricken. I agree with you.
And then I think that when you're talking about credibility of prospective witnesses and court personnel, I think that so long as you are not doing anything, that's my client or I, to endanger the personal safety of court personnel, or you're not doing anything to try to intimidate witnesses, you are simply making public statements about your trial, I think that that is okay. I think statements, there has to be a distinction, and I don't know how you would word this differently, but the statements really need to place either the administration of justice in a position where it's not going to be fairly administered, or you are putting the physical safety of either a judge or a witness or a juror at stake. And that's where I think you've got to be very, very careful about, wording it is one thing, but how it is interpreted and applied is really more important.
All right, so does that mean you're telling me that your client is free to say, the people at the commercial bank, I know them, I've dealt with them, they are liars, they're going to come into court and falsify records, I wouldn't believe it, I'm telling you now, these are liars because I know them, up or down?
Up, no problem with that. I don't think that should violate anybody's, I don't think that inhibits the prosecutor's ability to get a fair trial. I think that makes sure, especially in a case where a defendant, like my client, is a public figure, she has the right to get her point of view out to the public. And I don't think in any way that constitutes any danger to the personal safety of those witnesses.
Let me ask this to Tandy Lau, reporter.
Excuse me, Judge Rosenblatt.
Sorry?
I do have to interrupt very briefly
sure.
to
Sure.
share the first CLE code word here for those of you who are attorneys looking for continuing legal education credit. I think this was a little on the nose when I picked it earlier. That code word is speech. We are talking about speech right now. That is spelled S-P-E-E-C-H. For those of you who are attorneys looking for continuing legal education credits, your first code word is speech. And Judge Rosenblatt, Martina Stewart has had her hand raised for a while.
All right, well, please go right ahead.
Yeah, I wanted to just reflect a little bit on what Judge Cronin had said. And one of the things I like about this fact pattern, which if I was in law school, I would be sweating if this was like my final exam question, is so many times in this hypothetical, the interests and the positions of the media are actually aligned with the criminal defendants, right? But everybody keeps saying there is a constitutional interest in the fair administration of justice. But it would seem to me that the Sixth Amendment interest belongs to the defendant, and Ms. Tusk keeps waiving it because she's wanting all the same things at various points in the hypothetical that the media wants. I just point that out. I don't know the answer, but my brain has kind of been noodling over that for the past couple of days. So if we're intent on having a gag order and imposing, contempt and all these sorts of things all the way through this hypothetical, we are doing that on behalf of the government, the people who want the criminal laws enforced, the witnesses, the jury, the court staff, all of those people. We're not protecting the defendant in this hypothetical because she wants the same thing that the newspaper wants, as far as I can tell, at almost every step along the way.
Well, that's a very good point. That's exactly where I was trying to drive at, and see whether and to what extent the interests of the defendant, Tusk, align with the interests of the media. And I'll ask Tandy Lau to comment on that. Would you stand shoulder to shoulder with Tusk in fighting this, in fighting the language here, or do you see yourself as completely free to do anything because you're not even a party, and you cannot be held in contempt for anything?
I think that's a really good question, actually, because I think obviously as reporters, while I think we say interests align, we want our reporting to be as objective and untied to any parties as possible, right? We want We want what we see as fact to be communicated to the public. And now, so by aligning ourselves with, say, a defendant in terms of SCAG order, I do think that that is a bit of a concern for me, because I think I'm sure if you've seen any reporters out working in the field and a TV camera points to us, our natural instinction is just to move out of the way, like to just be out of the camera shot. And the reason why is because we never really want to be the story. We never want to be part of the story. We want to be the ones that tell the story. And by really participating in this now, I think it can, at least to the public, like maybe misconstrue like our intentions in terms of telling the story, which I think if, say, this reporter, in this case, Sandy Scoop, she wants to talk about these, these Caribbean holdings, and to get that story out, she would need to really be able to speak with people, right? And I think the difficult problem with that is at the same time, to basically hold Miss Tusk accountable, you're also kind of throwing your hat in the ring with her. So in my opinion, I think it would be something I would be very, very wary of, because you never want something to undermine your story. You never want to be a part of the story. You always want to be the person telling the story. Now, of course, I think modern kind of the way that a story like this happens, with kind of this like very, very boisterous social media presence and all that, it might be impossible to be, quote unquote, fully objective in the same standards that I think we are traditionally used to as reporters. I think it is high time to move past that, right? But at the same time, I think you never want, especially with kind of a figure like this, you never want any sort of doubt towards your credibility, because you have people challenging already the credibility throughout the story of people. And what you want to make sure of for whoever reads the story is to have that information and to be able to trust it. And I think participating in throwing your hat in on the defendant's side very, very in a very pronounced way, I think could really, really damage that. So I would say I would be very, very wary and very, very hesitant to consider something like that.
So with when Mr. Gavanti was, if we were pretending that I was on the bench framing and drafting this gag order, I agreed and I struck the word agents. So I would ask you, what's wrong with this gag order? I had understood Dana Green to say quite candidly and credibly that there might be room in the world for gag orders. It depends on the language. So looking at this gag order now, what language would you have me change or strike so as to suit your needs?
I think, let me take a quick peek. Just
You want to think about that a little bit or come back
Call
later?
your lawyer, Tandy. Call your lawyer.
lawyer,
Good. Rex, go ahead.
Now, this is actually where an editor, where a reporter had better get an editor on the phone, and the editor better get the lawyer. However, there is an interesting question here, because it looks like Tandy or Sandy Scoop here has actually done created a story about this lavish lifestyle, information of which seems to have only been able to come from the prosecution. And I'm wondering, I might turn to Joe Kretsch here to see if you were representing the defendant in this case, and you saw a significant story in which, Tandy Lau is concerned about being identified with one side or another in a case. I don't see where this information could have come from other than the prosecutor, a lavish lifestyle, a list of the names of prosecution witnesses. Would you try to take any action against the prosecutor in this case?
This is assuming that I'm representing the defendant here.
Yes.
In a defamation case, or in the criminal case itself?
In the criminal case, yes. Let's say it's a criminal case.
I guess I could see doing that. It's not a situation I've been fortunate or unfortunate enough to be involved in because I'm usually in the civil context here. But I think you could make an argument that where else did it come from? I mean, it's conceivable it came from Ms. Tusk herself, but that seems unlikely. But I would tend to think that trying to get this information out of a reporter, for example, would be close to impossible, at least in New York, right? I mean, the source privileges are so strong that if we're assuming we're in New York, I don't see how that would realistically happen.
And if we're in a federal case, are we because there's no shield privilege, are we more imperiled? Dana Green, let's say that you have a reporter calling you saying, I've got a problem here because I can't divulge who my source was and I'm being pushed on this.
Yeah, I mean, I think even if you're in federal court, you're still going to have some source protection. It's not that there's no source protection in federal courts, but yes, depending on which jurisdiction you're in, I think every state except I think Wyoming and Hawaii now has statutory protections. But even in the absence of statutory protections, you would still have First Amendment and common law protections to argue. And here generally, right, with varying factors coming in, but generally you have to show at a minimum that the information that the journalist has would is essential to the adjudication of a vital issue in the proceedings, and that there's no other reasonable way to get it. And here it would seem that there are many options before you get to that point, including potentially placing one of the parties under oath or attorneys under oath and questioning them about the source of these leaks. And I have seen that kind of situation arise where there's allegations that a party has violated a protective order or violated a gag order and leaked information to the press or others, in the world.
So
yeah.
Let's just move along here because we have so many issues we could keep talking about here. For starters, let's just talk about one thing in the hypothetical, which is about to happen here, and that is a great deal of hubbub outside the courtroom, including an officer being struck on the head by a protester's sign. Officers respond by subduing people and herding reporters out of the way to a spot where they actually can't see the clash between law enforcement and the demonstrators who are there on behalf of Ms. Tusk. This, of course, concerns, in fact, one of the reporters has a cell phone taken away. So I might ask Michael Gerber here whether there's you have a sense, and you knew that this was going to be coming, that there was is this a lawful detention, number one? Is there ever a circumstance, you think, under which it may be appropriate for a cell phone that seems to be used in this circumstance to be seized?
All right, so I guess start with that last part of it. To the extent, it's a little bit unclear from the way the hypothetical is written, but if you're assuming, and I think this is what was intended, that the officer is taking the reporter's cell phone as a means of preventing the reporter from recording what has happened. I cannot imagine a scenario where that's okay. I mean, maybe I need to have a broader imagination, but to the extent you're talking about an officer, taking action in order to interfere with a recording of police action in a public space, right? So again, maybe that's a quality that's important here. Public space, public police action. Officer acting to interfere with that, seizing a reporter's phone. It seems like a huge problem, if that's what we're talking about here, right? Violation of our patrol guide, violation of First Amendment, violation, frankly, of city law, state law. So there are a million problems with that. You know, with regard to the first part, though, the moving the reporters essentially offset, you know, look, that is really going to depend on the particular facts, right? So I think there are two pieces to that. One is, you know, first and foremost, okay, where will the reporters be safe, right? It is totally appropriate to move the reporters away, everyone away. We're clearing a space, you're moving people out for public safety. You certainly can move reporters as well in order to keep them safe. Now, if you can do that, consistent with them still being able to see what's happening, report on what's happening, that's what we need to do, right? So if we can get reporters to an alternate location where they are safe, but can see what's happening, can report on what's happening, that's what we need to do. Now, you can imagine situations in which, given what's happening on the ground and given the layout of the space, that no, in order to maintain public safety, we need to move the reporters around the corner, and that's what we're going to do, consistent with public safety. So I think it's really going to depend both on just the facts on the ground, how bad things are, how dangerous things are. It will also frankly depend on the physical layout that you're dealing with. There certainly are times when just the way things are laid out, you can move reporters back sufficiently, they can still see what's happening, can still report, but we don't have concerns for their safety. It's not always the case, so it's really gonna depend, I think.
Rex, can I jump in here? Because there is one viewpoint which we haven't heard. I'm going to backpedal a bit, that we haven't heard from Nick Lehman, and I would want to ask Nick Lehman, who's a journalist, professor, and former dean. Nick, is there any room in your universe for a gag order at all? And if so, what's the scope of something that you would regard as okay?
Well, you know, first of all, just to help me out with the legality, as I read the gag order in the hypothetical case, it doesn't place a restriction on the reporter, it places a restriction on the other people talking to the reporter, right?
Yes.
So therefore, narrowly in that case, if I'm the reporter, Sandy Scoop, and I read the gag order, can I say, well, I'm fine with this gag order because it lets me do whatever I want, right?
It doesn't bind you.
It doesn't bind me.
Appears to bind.
Right. So what we do constantly is try to obtain information that is not supposed to be public information. We sort of grant ourselves the right and then hope, you know, there's that saying that you may have heard, it's better to beg for forgiveness than to ask for permission. So like in the Trump tax return story that the Times did, you know, and that's one of many. Or Pentagon Papers is another one where the giver of the information is legally barred from giving it to the receiver of information, right? But the receiver of information, the press, can say, well, that's not my problem. In fact, it's my job description to try to get people barred from giving information to violate that and give it to me, right? So on the question of can any gag order be justified, you know, the true reporter's id answer is, that's not my problem. I'm paid to get stories. I'm not paid to think about when I should be restrained, and I'm going to try to be unrestrained and let the system decide when to restrain me. But, you know, if you really press me, I'd say, sure, yes, I grant in the abstract that there could be hypothetical gag orders. I wouldn't say no gag order has any justification. So I guess that's the best I can do. I'll give you an example from long ago. If you read the old Woodward and Bernstein book called All the President's Men, I don't know if any of you guys have read this, but there's this point when they're recounting how they got the Watergate story, where they have these sort of guilt pangs because they're desperate. You know, the story's kind of dying and they want to keep it going and so on. And they start calling members of an impaneled grand jury. It's still impaneled, to try to get them to talk. And they do to some extent, if I'm remembering it correctly, but then they feel sort of guilty about it because they say, in effect, I know that it's wrong as a matter of justice and law to try to get information out of members of a sitting grand jury about a pending case. And I did it because I was just hungry to get a story. So that's a rare moment when you find a reporter publicly confessing that the legal restriction that applies to us is valid. I want to raise one other point, just a sort of anthropological point about press behavior. We had a former president who, I can't remember his name, but he's sort of similar to the character in the case. And what we found in the press is that on the one hand, and this is sort of typical of us, on the one hand, we love to get up on our high horse and say, we are the advocates of the public. We are guardians of the public interest in these extraordinary political circumstances. On the other hand, this particular president was very, very good for us commercially. And all of the, ratings and so on of the so-called liberal media zoomed upward. So when we would lavishly cover everything about this former president, were we motivated by sincere public interest, or were we motivated by commercial considerations?
Well, that's between you and your conscience. So we'll leave it at the moment. Rex, maybe you could pick up, but thanks so much for your insights on it. Really appreciate that, Nick. Thank you.
Well,
Rex,
before I just am worried about losing the thread of one issue that is not specifically presented actually in our hypothetical, but is essential. And that is perhaps coming around to us in real life right now. And that has to do with the right of the public to have access to court proceedings. I mentioned this earlier. Most of the public gets its information through video these days, not through reading ink on crushed trees. And that means that the vast majority of Americans are actually shut out of courtrooms because the federal courts specifically prohibit cameras in the courtroom, and in New York State, it's extremely limited. And notwithstanding the fact that there were now 20 years ago, a couple of experiments in media law in New York State in which cameras were allowed, and in which the findings were that, in fact, the administration of justice was not inhibited. So I wonder why we are feeling as though this is not an issue that ought to be one at the forefront. In this particular scenario, for example, we have attorney watchover on behalf of the media moving to allow cameras in the courts. This is further on down in the hypothetical, filing an application to provide live in-court audio-visual coverage on behalf of the Media Coalition. Maybe we find out, DA Clark, are you going to oppose cameras in the court because I believe under the chief administrative judge's rulings, you could have an extraordinary case where it would be allowed? Would you want to have the cameras in the courtroom in a case like this?
It really depends on what the underlying factors are as to the safety of the proceedings. Like a lot of times, even now as a DA, I could tell you now that I don't oppose it, because I think, trials should be open. There's limitations and judges do that. As a judge, I've done that, taking the application from the media, deciding whether or not it could, and figuring out the limitations on where maybe one still camera, maybe, still photos, no video, there's ways that judge can administer that. But I think that the biggest thing is whether or not the jurors are going to be safe, whether or not the witnesses, are going to be safe, when they're testifying, the judge, there's a lot of factors. In this one, this fact pattern is so sensationalized. I think that there's so many dangers that could fall into there being dangers to the parties involved, that I think that perhaps I would make the application, but really I wouldn't. I think it should be open to the public. But with that in mind, I think the safety is the biggest factor. And if I thought that there was going to be a danger to look, we go through this with gang cases, where witnesses may be in danger because people come into the courtroom. They even using just their cell phones. All of those things are limitations. As far as the press, it's a little bit different. In New York, yes, for the proceedings, for the most part, they're not allowed in because of the administrative judge's order. But sentencing, it's allowed. And I mean, recently, I've had a number of cases recently where I've been there with the victims, or the survivors of a crime, when they stand and give their victim impact statement and the judge, imposes the sentence. It's allowed. So it's very difficult. It also takes up a lot more time because you have to figure out where the camera is going to be, where everybody is. But it doesn't stop reporters from being inside the courtroom and still reporting. So therefore, because they still have the ability to be inside, does it have to be on video? Does it have to be pictures? No, because it's still open to the press.
Dana Green, the New York Times is video almost as much as it is print these days. Are you going to be making an argument on this if you can?
I think you mentioned sort of that there have been studies about cameras in the courtrooms. To me, one of the great sort of opportunities of COVID was that we went through a national experiment not in terms of COVID, but in terms of access to the courts. We went through a national experiment in what would happen if we allowed greater access, digital access to what's happening in courts, either through video or through audio. And often these issues are coming up in cases like this, right, where it's highly sensationalized. But during COVID, what we saw was just very broad access via audio and video to courts in order to fulfill that duty of openness while keeping everyone safe. And I sincerely believe that what we saw was that in the vast majority of cases, the sky did not fall. And in fact, what you saw was really a fulfillment, to me, in a beautiful way, of our democratic principles about public access, where people who are not physically able to make it to court, who are on the other side of the country, who don't have the economic opportunity, could be there to see what was happening, either to loved ones who were involved in cases, or in the case of the New York Times, resources are not unlimited. We will have reporters in New York who are trying to write about national issues. We can't have someone in the courtroom all across the country. So just recently, I was working with one of our reporters who's doing a big study into healthcare, and he wants to follow what's happening in a series of cases where health insurance companies are litigating. And he was applying to the judges, asking permission, please at least have an audio feed so that I can listen, because the barriers to access are really significant. I mean, he can't fly all over the country to be in court every day, A, and B, transcripts are even hard to get a hold of and very costly. So to have, at a minimum, a live audio feed, I think can often balance the interests of trying to protect, avoiding sensationalism, but allowing sort of greater access. And then secondly, I would say I'd hold up the Derek Chauvin trial in Minneapolis as I think a great example of how cameras can be handled very sensitively and really be an important part of public justice. There we were part of a coalition of news organizations who pooled together. We had, a single fixed camera. We worked with the chief judge there to make sure that, the camera would never show the jurors, to balance sort of the, very substantial and important rights of the defendant and the jurors and everyone. And I think that trial, at a time in that city where the outcome of that trial really was so significant to the community, I feel that really fulfilled the role of public justice, and people seeing that it was a fair proceeding, seeing what the evidence was. I think it was really important. So yes, I am personally, I will say, a big advocate for openness. I think that it can be handled correctly. It does require, collaboration, maybe is the wrong word, but dialogue between the press and the court and the parties to ensure that, all of the appropriate steps are being taken. But it's something that we of course do seek. We did seek in the proceedings that are obviously, something of an inspiration to our hypo.
We just
Let's-
asked Commissioner
yes.
Cravanti how you would feel about this. So on behalf of your client, are you going to, in the hypothetical, defense counsel Pignacio supports the media application for transparency. You think defendants are generally disadvantaged by video coverage, or is it a good idea?
They might be generally disadvantaged in certain kind of cases. I think that certainly in the O.J. Simpson case, for anyone who's paying attention, I don't think that his cause was helped by the fact that that trial was broadcast live throughout the country. In this particular case, I mean, my client has a strong interest because I presume, you know, he is making the statements he's making about the prosecution, the motivations and everything else with some degree of responsibility. And therefore, in this particular case, I would strongly advocate and have no problem taking my client's position to the court and urging that cameras be permitted in the courtroom with the protections we all just discussed. No need to be filming jurors or anything else. Just making sure the press and everybody else across the country knows what's actually going on in that courtroom if you think that the prosecutor is a political hack who's out to get her.
Hal, Rex, should we be going to the audience at this point? I'm looking at the clock.
No, I don't think. I think it's a little too soon.
Okay, good.
Let's keep going.
Okay.
We do have, Tandy has his hand up.
Oh, Tandy, please. Yes.
Hey, how's it going? I think when we talk about kind of a case like this, and I think when we talk about cameras, I think one of the things that, like, as a reporter that I'm like very willfully aware of is I think hear a lot of people are like, why do you want to be a reporter? Like it's such an antiquated, especially in print. And I think it really kind of fits into this idea of these like standards that we have, even though, as the professor says, there are no real like true standards. There are a lot of standards that are kind of quietly set, right, for reporters on how we conduct ourselves, how we conduct our reporting. And I think for a case like this, it becomes very difficult to kind of fall back on the kind of conventional, like conventions of journalism in like print and paper to really talk about, you know, like a former governmental candidate who is like, you know, making these like very, very, very like incendiary like comments and all of that. And I think the best way to really address that is to have as much kind of transparency as possible. So cameras, obviously, if you're calling like the prosecutor a hack, what better way to show that the prosecutor is not a hack by, you know, having a camera on them, right? And if they are a hack, it'd be great to, you know, show like, you know, what they're actually doing, because I think as a reporter, there's only so much that you can do when you sit in that courtroom with a notebook, especially if the court officer is constantly looking over at you to see if you're on your phone. Really, there's so much that you can write. There's so much that you can kind of transcribe, right? So I think because of that, the camera really kind of really fast tracks that. And beyond that, I think when we talk about cases like this, and I think you see later in the case study that like, because the reporter doesn't get published, you see like blogs like take over. You have this like kind of professional standard. I think all of our institutions that like us in the room really kind of typically abide by in terms of professionalism, in terms of this kind of like ethos that I think somebody like what's her name, Miss Tusk in this story does not abide by. And it makes, like the professor says, it makes good television, but at the same time, it becomes very difficult to age-old journalism conventions to kind of properly tell these stories, right? So I just think that in regards like this, I think you handle it with the notion that there are going to be external factors like social media. Like if you don't write this story and you don't have reporters talking to people, you'll still get these maybe wild things out there on social media regardless, because that's just kind of the nature of where we're living right now.
Let's get just a moment here, and the hypothetical offers us an opportunity where there aren't real people like Tandy or by Sandy Scoop, handling some of these questions, where we have a piece that shows on a website, justus.org, what appears to be the defendant and her lawyer in a romantic setting, which may well be considered to be, I suppose, defamatory. And so there's a question of whether there might be a lawsuit filed, a libel suit, in fact, with defendants, not only the publisher of justus.org, but also the company that created the artificial intelligence program that created this content. And so I think, Joe Kretsch, you're the guy that we turn to as the expert here on this. If you're the plaintiff's lawyer, where you're facing a situation where you have content that seems to have been AI generated, who's your defendant?
You probably, am I muted? No.
Oh, you're
you
good.
Probably sue everyone, is the short answer, because it is so muddled. I mean, I think you sue for sure the publisher, right? I mean, that was the premise of New York Times v. Sullivan, right? It was an ad. So having published it, I think that there's an argument that they are liable. You sue the advertiser, right? That this programmatic ad company, and you sue the AI company as well. I actually tend to think that the AI company argument is the weakest under these. I know it's tempting because you probably have big money behind it, but it all depends on how it's triggered. I mean, let's assume that the AI company is actually responsible for publishing it at all and not just creating a tool that's hosted on another company's website, right? Which is the kind of thing that's happening with ChatGPT, for example, right? Maybe the programmatic ad company itself is running it, in which case suing the AI company is like suing the maker of a typewriter. It's just a tool, right? For defamation. Assuming that the AI company is sort of just hallucinating, as they call it, and making up fake facts here. First off, I assume that the advertiser knows that. I mean, it depends what the prompt looks like. If the person putting together the ad said, create a picture for me that they know is fake. I mean, how is that much different from saying, lie to me, right? Repeat the following lie after me. It feels like at that point, the person hearing it, the third party to whom it was published for purposes of having a viable defamation claim, is not really a third party to it at all, right? So I think there's a question there about what, not only are there damages, but is there even a publication element satisfied, right? Because it's sort of somebody sitting by themselves in a room and typing into an AI chatbot and hearing back exactly what they asked to hear. The advertiser seems like potentially the most liable here because they should have done some sort of checking, you would argue. Now, again, there's going to be questions about what did they think the chatbot was doing, right? If you type in something, tell me the following lie, right? Create this picture that I know doesn't exist. Well, good luck under any legal standard, right?
But your weakest case is going to be against the publisher, isn't it? The publisher who just accepts programmatic advertising, that is, it comes in by bid in a fraction of a second, and a publisher doesn't really know what's on that programmatic ad. That's why it's called programmatic. It's just done by a program. So probably the publisher who actually brings this is going to be pretty quickly dismissed.
Well, it depends on if they know. What do they know about what they don't know, right? If they know that they are using an ad company that is using AI, for example, like let's just tweak the scenario a little bit. And they know that AI hallucinates. I mean, in fact, you can probably point to this publisher, Justice, having written articles about AI hallucinations and how unreliable it was. I think as the plaintiff there, you say, you knew this risk existed. This is recklessness. And we should at least be entitled to discovery into what kinds of standards you were applying to the advertisements. Like in Sullivan, the Times said, well, this advertising agency was very reputable, the ones who gave us this, the people who were, sort of the signatories to this open letter that was the ad, are all very reputable. We didn't do any independent fact checking, but how could we have known? If if you know that you aren't doing any fact checking of these programmatic ads and you know that they're using these kinds of irresponsible tools, maybe you are on the hook. It would be an interesting question that's probably going to come up.
Interesting thing. Al, I think we're about to move into a voir dire here.
Well, yeah, there was a couple of little things that that I, from my mind, could use a little bit of clarification. That is the anonymity of the jury and the 5-year taboo that the judge would impose, saying that the media is barred from talking to the folks on the jury. Maybe that's because the judge would tell the jurors, look, folks, I know that none of you are in a hurry to sit on this case, that it could upset your lives and it could be traumatic. So I'm going to do whatever I can to protect you. The press should lay off of you for 5 more years. So that's one thing. Then the other thing is the anonymity. I'm not sure what that means. Maybe we could get some thoughts about what anonymity means, because one way of saying anonymous jury is that the public doesn't know the names of the jurors, but should the parties not know the names? How are they going to look up online and see whether any of these parties have said it or done anything that would show an extreme bias? So when we say anonymous, I would assume that means that their names don't go out into the public, but the people in the courtroom know their names, which would be revealed at the sidebar or at the or in chambers. Does that meet with anybody's agreement on that point?
I could answer that somewhat, and that's part of, I guess, closing the courtroom and you know, making the juries anonymous and those kind of applications. Yeah, those things are important because, one, you know, like a case like this, highly sensationalized, you're not going to get a lot of people raising their hands saying they want to sit on this case, you know. And then if you do get people that really raising their hand, they want to be on it, it's like, who are these people? You know, so you always have that push and pull. But be that as it may, it's a civic duty. Everybody has to do it. It's very important. So you got to make sure you do it in a way that people still want to serve because they have to serve, and that it's done in a safe way. Normally in New York State courts, it's like, you know, you can't close the courtroom for jury selection or anything else. Now, there could be protective orders that we would apply for that ask the judge to limit the access of who can go in, but you know, jury selection and trials in general are public and they have to be public, but it doesn't stop the court or the presiding judge from putting some limitations on it so that there still can be fairness and a balance and safety at the same time. So I think the way that it works, at least in New York State, in my experience as a former judge, as well as the DA now, is that, you know, the names and addresses of those jurors will be kept confidential just for the parties, but just not for the general public.
That makes
a way to balance it to make it safe.
The parties can look them up. One thing I would want to just retrench on, when I said as a court, I would strike the word agent. I was just acting out something that a judge might or might not do, not what I necessarily believe, because agents can be surrogates who can violate the order with the same degree of intensity as the defendant. So I was just showing how process might be negotiated, not necessarily that I come down on one side or the other.
Judge Rosenblatt, we have Judge Cronin's hand is up.
I'm sorry?
Judge Cronin's hand is up.
Go right ahead.
So I just want to address some of what you just asked about regarding anonymous juries as well. Before I became a judge, I spent a period of time as a national security prosecutor here at the U.S. Attorney's Office and had some dealings with applications for an anonymous jury. I think most likely it would be a situation where the attorneys at the very least would know the names of the jurors and it just wouldn't get out anywhere beyond that. You know, it all goes down to the fundamental concern that jurors feel free to decide the case based on the facts only offered at trial, based on the law, that they feel comfortable applying the law to the facts without any external pressures or feel of reprisal or retaliation. But in extraordinary cases, there can be an anonymous jury. This circuit, in the Second Circuit in federal court, there are a few factors that a judge must consider. They're probably what you would expect: the nature and seriousness of the charge, the potential threat of corruption to the judicial process. That could be threats to the jurors or efforts to manipulate them, and the expected publicity and media coverage. And all of those factors kind of come together to support using certain jury protection measures if there is a reasonable fear that there might be efforts to intimidate the jury. Now, I will say, though, if a judge is going to have an anonymous jury, it's important to think about what measures and precautions can be taken to minimize any adverse effect of having an anonymous jury on the defendant. That could be conducting a thorough voir dire of the jurors to uncover any potential bias, giving the jury a plausible, non-prejudicial reason for their anonymity. To that extent, it might make sense to let the jurors know that they're not being treated particularly differently. Now, some measures are unavoidable. If you're having the jury meet at a certain location to be picked up for transportation to the courthouse, they're going to realize that's something out of the ordinary. But one thing that I think judges have done is telling jurors that, and this could be in the voir dire process, for example, that selecting an anonymous jury is not an unusual practice. That's been followed and applied in many cases. In the district I'm in, it's been applied in terrorism cases for sure, organized crime cases as well, I believe, and that by having their names not being publicly revealed, it may ward off pressure from the media to talk to them after trial or infringe on their privacy. But a major concern that needs to be in place is making sure that by having an anonymous jury, the jury is not thinking that this means it's more likely that the defendant is guilty of committing the crime.
But what about can I ask Dana Green, the media interest in having the names of juries? I think of the case of Rod Blagojevich, the former Illinois governor, where the fact that the media had access to the names of jurors and therefore they were able to get information about a juror that I believe led to one of the jurors being disqualified, which information they would not have had, which means a fair trial would have been inhibited if the media hadn't had access to that jury information. There is a significant public interest, as the constitutional requirement for open courtrooms suggests, in having that kind of information available, isn't there? Couldn't you make that argument? And would you have standing to even make that argument?
I mean, that argument certainly could be made. I think the point is, though, that anonymous juries are the exception, and they're in extraordinary cases where there's a very compelling interest for the jury's safety to keep their names anonymous. And in those situations, the judge will apply the factors and determine whether or not that weighs in favor of keeping them anonymous.
Well, if Mr. Gravanti's client would keep his mouth closed, you might not have that much danger to the jurors,
Well, but Mr. Gravanti is in a highly politicized case where there is no allegation that he is physically, he would place any juror in physical danger, unlike an organized crime case where there is a precedent for keeping jurors anonymous because organized crime cases, is a demonstrated history, and it's been proven that certain defendants in the past have, in fact, tampered with juries. But in a case that is highly politicized, I think I absolutely have the right to have access to all social media and any other research I can do concerning a particular individual to make sure that I'm getting a fair jury.
Does anyone want to address the 5-year injunction that the court put on the media?
Well, I would just ask Dana, I mean, isn't it sort of a norm that may not apply in every case in trials that are of high interest, that once the trial is over, reporters can call the jurors and say what really went on in the jury room?
Yes.
So then the question becomes, going back to, it's better to ask for forgiveness, ... If there were such an order, I'm guessing your editors would say, just do what we usually do, and if we get in trouble, I'll call Dana Green and she'll deal with it after the fact.
Well, actually, it's funny you say this because in my notes in preparation, I had written down, I don't know why you would make this motion, the motion to the judge asking, about speaking to the jurors, because it's sort of backfired in exactly the way that you're kind of risking by asking for it, in the sense that once the juror's duty is done and they've left the courthouse, they're like any other citizen, right? You're perfectly free to approach them and ask them for the time, or to ask them about their lives, So I would probably not ever have made this motion. But in terms of in terms of the gag that's then placed, it seems to me obviously unconstitutional. But it is well established that when there is a prior restraint, you're not supposed to violate it. You are supposed to challenge it. Even if the gag were unconstitutional, there is some precedent that you can still be punished for violating it, even if it's found to be unconstitutional later. So certainly the more the safer option here would be to immediately challenge it on its face, rather than violate it.
I'm so glad you're saying that, because because otherwise it might be something like a breach of trust. The judge is telling the jurors, look, this is not a case anybody wants to sit on. This is a once in a lifetime for anyone. You are 1 in 10 million to get nailed for this jury duty here. So let me give you my assurance. You're going to be left alone. They're not going to come after you after the trial. If you have a problem with that in the media, tell me now, and don't then come around later and then in a contempt hearing. That would just create needless turmoil, because if it should not be, if that injunction should not be made by the court should know about it at the outset when the court is making promises to the jury.
Well, I don't think you can override constitutional rights based on promises. I think I don't think that would really be valid. I mean, nor I think can you waive your constitutional rights by not intervening immediately. Many members of the media may be totally unaware of what the judge's comments were. I don't think I don't think core constitutional rights can sort of rise and fall on those kinds of things. They're not generally considered waivable.
Good point. Good point.
Martinez, if I could just add,
sorry.
If I could add one thing, as a defense lawyer, I would always object to that. And depending on what happened in that jury room, an acquittal cannot be undone. A conviction can be. And as a defense lawyer, you've always got an interest in wanting either the press or defense counsel, anyone, to be able to talk to the jurors after a trial, because it can only help you, it could never hurt.
Martina Stewart, you had your hand up.
Yeah, so I cover legal journalism now. I used to actually cover national politics for a long time. And so what I'm seeing here is the 5-year bar. There's got to be a presidential cycle landing somewhere in this 5-year restriction. So I would be very concerned about basically taking the jurors off the table in terms of any more stories or reporting that, I used to work at USA Today and at CNN, maybe not so much for Bloomberg Law, but at other outlets. If this is someone who has national political aspirations, to say that the jurors are barred from talking to the media for 5 years is very problematic.
Well, just a reminder, it's real life. The accomplices, the name we remember is Derek Chauvin, the cop in Minneapolis. His accomplices, the jurors in those cases were barred for 10 years. From speaking to the media. So,
but I don't think that they were likely presidential or vice presidential nominees in those 10 years.
Right. Good point. Tandy, you have a hand up here.
And I think one thing as a reporter, I think one of the things that I mean, for a story like this, I'm sure like reporters will probably have like a countdown clock or like a reminder 5 years from them, but like potentially Sandy Scoop or the other reporter probably not going to be working where they are. Journalism industry changes a lot. So the question is like, what story ends up being written when those jurors like can talk, right? Like Martina said, maybe it could be a presidential cycle and it becomes newsworthy. But if it doesn't, it likely becomes more of like an enterprise story where a reporter somehow remembers or like has it in their like little pocketbook, where they have the same old cell phone that they had when they were reporting on the story, and they're like, hey, 5 years are up to this date. Let me go reach out and talk to some jurors because they can now talk, right? And I think it really beckons the question of like what kind of story can be written, what sort of actionable kind of reporting can you get from that? And I think one of the other things that I would be really concerned about is at that time, I mean, 5 years is a long time. What do the jurors remember? What sort of things can you necessarily factually prove, fact check? And even if it's something that the jurors wholeheartedly believe, I think the retelling of what happens in that room immediately after, as when they're, immediately when they're kind of done with the case or walk out, they talk to they hop on a call with you and they tell you how it felt, the tenseness and all that. I don't think it could be properly communicated the same way 5 years down the line when you're like, hey, what happened? And if you almost have to be suspicious if they tell you like every little detail that they remember, and you're like, that was 5 years ago. How do you remember that? You almost have to be a little bit more suspicious of that. So I think in terms of the actual story that would come out from a reporter's angle, that would be like a major concern for me as a reporter, just because you have an important news story that can come out immediately after. And if you don't have access to jurors, and for whatever reason, your counsel or just the ability to get access to these jurors just doesn't happen, could really, really lose. It could be lost to history. I think that's the best way to put it. It could really be lost to history, and even a retelling 5 years later could possibly not be the same as getting that comment just immediately after, or maybe even like 1 or 2 months later.
Right. Joe Kretsch, you have a point on this? Whoop, we're being interrupted.
Apologies. Before you get started, our second and final continuing legal education code word, for those of you who are attorneys looking for CLE credit, that second and final code is jury, spelled Jury. We are having some conversation about juries at present. Again, attorneys, your CLE code word is jury. Thank you.
Okay, thank you. And we will.
Before we pick up with Mr. Kretsch, I just want to add that we will be opening up for questions from the audience in the next few minutes. We don't have any in the Q&A box at the moment, so if you have them, now is the time to let us know. Thank you.
Okay, Joe Kretsch, you were about to say.
Thanks. What I was thinking about is the difficulty with technology these days of really keeping a jury anonymous. There is just so much technology with which you can track people's faces. I mean, if you want to find out who jurors are, I worry that you will, and that it is borderline impossible these days to really keep that out. And if you have an injunction like this, you end up with the risk of having sort of a two-tiered media reporting on the facts here, where you have bad actors who don't care about the law roaming around the site formerly known and reporting perhaps really untrue and dangerous things about the jury. And then you have more reputable news organizations, like some of the people on this panel, who will follow the law and won't talk about it. And I think we saw that happen to some extent in the first Trump impeachment, right? Where the whistleblower, the unnamed whistleblower, some people figured out who it was. I don't know how they figured out who it was, but you ended up having this kind of dark web reporting on it while the mainstream media refused to name him.
Mm-hmm. I might actually, this is an opportunity for us to go back to Michael Gerber, who we've heard a little less from than some of the others, and so we don't want to let you off the hook, because there is the sense that the NYPD now has. Are there tiers of treatment for the media? In fact, and I shouldn't, I guess, just single out NYPD. We should talk about the any public entity, that because of the loss of authority and the loss of singular focus on legacy media, there are so many players out there who purport to be journalists that you can't really quite have a policy that applies to journalists per se, because everyone is. Do you have a way that you approach the notion of media with respect to media law, with respect to how your department deals with the media?
Yeah, and it's a great question, and there are a few different pieces to that. And one is the fact that figuring out, okay, well, who's a journalist, right? Obviously there could be a lot of ambiguity in that. And while yes, there are sort of formal city hall press passes, that's obviously relevant, but if, for example, you look at the recent protest settlement, it's gotten a lot of attention. That settlement by its terms speaks more broadly and expressly says you have to look beyond just the press passes. You have to look beyond who has press passes issued by City Hall. On the one hand, that obviously you can understand why that is, because given the world in which we live, you have lots of journalist reporters who are not with sort of an established known organization. At the same time, just to be blunt, it can pose challenges in the field. You're dealing with dynamic situations, fast moving, fluid, and for sort of frankly cops on the ground to be able to figure out, is this person a reporter, is this not a reporter? Sometimes it's crystal clear, sometimes it's not so clear. And that's a challenge I think we're just going to live with going forward. There's no simple answer to that. And then in terms of just, I would say, access, more broadly, some of that's clear. Obviously, it would be, inappropriate to be discriminating, among press outlets based on sort of, content and viewpoint on the one hand. On the other hand, to the extent you're having a press briefing and the question is, okay, we've got 20 seats. Who's getting the seats, right? At some point the room is full. It just is. Or reporters are asking for an exclusive. Hey, can I talk to this person? Can I go along with that person? You can't do it for everybody, and to try to do this in a reasonable way, in a fair way. But I do think, to go back to sort of the premise of the question, yes, when we move far beyond sort of traditional sort of clear, okay, these are the news outlets and that's the universe of reporters. It's a lot more. There is a lot more gray, and it definitely presents a challenge.
Al, what questions have we failed to deal with here? Where are we?
Yeah, anybody with some observations that
We're nearing summation.
Middle of the night and said, gee, I wish we had covered that point. Feel free for anyone to jump in with that. We've covered a lot and opened a lot of grounds for debate and differences of opinion with a fair amount of agreements as well. But if there's anything that's been left unsaid that should be covered, please don't tell us in the middle of the night.
Joe Kretsch is here before the middle of the night. Here we are.
So the one thing that I think we didn't cover, because there's just so much to cover, I totally get it, was the hypothetical claim, defamation claim about that title, the incitement allegation, right?
Yeah.
The Artie Greaves story, that given the support from violent fringe social groups that Tusk's campaign for governor enjoyed, there's little doubt that the violence was the direct result of Tusk's call, which was nothing less than criminal incitement. And I thought that was an interesting one, because it's an opinion. It's like, as worded, I have trouble imagining advising any client that is a good case to bring. But part of the reason is because it's an evaluative opinion in which the facts underlying the opinion have been disclosed. And that's what leaves it protected, right? You know, you can't just say, you know, I think that so-and-so committed murder and not explain why, right? At that point, people are going to assume you have a good reason. If you say the person eats meat and therefore I think they're a murderer, it's like, okay, well, that's your opinion. You've disclosed your reasoning for it, and people are entitled to reach their own views about it. I've dealt personally with cases where you have something very similar to this, but they don't disclose the opinions, right? Like we were representing, my partner, David Pressman, and I were representing back during that same first Trump impeachment, Lieutenant Colonel Vindman, when on Fox News, they reported on the Ingram angle, they had John Yoo on, and he said, you know, in a professorial style, well, what you're describing sounds like espionage. And we wrote to Fox News about it because it spurred as many death threats as you might imagine. And people took it very seriously. And it was kind of an interesting scenario because you had Alan Dershowitz on the panel who wrote the very next day, I assumed he had a good reason for this. I've looked into it and he didn't, right? There were undisclosed facts. And you had John Yoo writing something online saying, I didn't call Alex Vindman a spy, which of course he wrote because he did. There's no other reason to write that. And he even went further and said, and I would have no basis for saying that. So thank you for the actual malice admission. So I think that, you know, a warning to all reporters, I suppose, as I'm playing the bad guy here on this panel, is disclose the factual basis for an opinion you're giving, and provided that those facts are true, you should be safe. It's when you wonder that's the problem.
You're saying that just that dependent clause is sufficient disclosure, given the support from violent fringe social groups, that is adequate, you think, to provide some sort of defense to a libel claim?
I think most judges would say so. But who am I? There are a lot of distinguished judges on this panel to perhaps disagree.
In addition, I'd add that there isn't anything in the context here that implies that the speaker would be in a position to know undisclosed facts. This is a person who doesn't have any apparent ability to know more than what's in the public record, which would also help.
Mm-hmm. Great.
Joe, can I ask you this? We all remember Alexander Vindman and those highly dramatic moments that he provided, particularly when he said, well, let's get into that. What became of him? Wasn't he discharged or relieved of his duties? And can you fill us in on what happened to the lieutenant colonel?
Without hijacking this too much, he did retire from the military. His potential promotion to colonel, and that's one of the most meaningful promotions you can get in the military, in terms of it's sort of like making partner for lawyers. That went sideways. And at the same time, I think you had various people in the Senate holding up all promotions. So I think he was done with that. So he's done.
And his brother is running for Congress, right? His brother's running for Congress in this cycle, I believe. So
really, a twin brother?
Yes, Yev's a good guy.
Oh my!
Also was a lieutenant colonel.
That's amazing. Yeah.
Right when they both walk in the room, and they're like, "But I'm Lieutenant Colonel Vindman."
That's that.
It's like the Castro brothers in San Antonio. Well, we've had, this is a remarkable conversation, and we're probably nearing the end of the time that we have, and I can only, on behalf of all of us from Fair Trial Free Press, I've been engaged in these things since Saul Wachtler was chief judge, and that's a long time. And I just have to say thank you so much to all of you for jumping in here with such good spirit and with such thoughtful conversations. Al, it's been pretty amazing, don't you think?
It has been the candor and the expertise is really enlivening, and we all learn a lot.
Yeah.
And I'll echo those sentiments and thank everyone on behalf of not only the Fair Trial Free Press Conference, but also the Albany Law School Government Law Center. You know, this was an experiment, as I said, with doing this particular program on Zoom. And, you know, we really were disappointed that we couldn't all be in the same room together, but I think it went well, and we honestly thought about postponing it and did not want to give up this fabulous panel, and thought it might be difficult to get you all together again on another date. So we are really appreciative of your participation in this, and it was well worth it. And I'm sure we will be getting high grades from all of our attendees and registrants. So we thank everyone for their participation.
Okay. Thank you all.
Thank you.
As a reminder to those of you attorneys on the panel looking for CLE credit, we did send CLE forms to you by email. Those forms need to be completed, signed, and sent to Lisa Rivage, our CLE coordinator. Those of you attorneys on the panel, I will send a follow-up email to you too. Well, thank you. Thank you all again.
Have a wonderful rest of your law day.